The 12 Presumptions of Court. All shall be considered rebutted. Canon 32:28. A Roman court does not operate according to any true rule of law, but by presumptions of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact, and are therefore said to stand true, or as truth in commerce. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor/beneficiary, executor Json tort, incompetence, and guilt. Number 1. The presumption of public record is that any matter brought before a lower Roman courts is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter. Unless openly rebuked and rejected by stating clearly the matter is to be on the public record, the matter remains a private bar guild matter, completely under private bar guild rules. And, number 2, the presumption of public service is that all the members of the private bar guild, who have all sworn a solemn, secret, absolute oath to their guild, then act as public agents of the government or, quote, public officials, unquote, by making additional oaths of public office that openly and deliberately contradict their private, superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. And, number 3, the presumption of public oath is that all members of the private bar guild, acting in the capacity of, quote, public officials, unquote, who have sworn a solemn public oath, remain bound by that oath and therefore bound to serve honestly, impartiality, and fairly, as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interests and cannot possibly stand under a public oath. And, number 4, the presumption of immunity is that key members of the private bar guild, in the capacity of, quote, public officials, unquote, acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith, are immune from personal claims of injury and liability. Unless openly challenged and their oath demanded, the presumption stands that the members of the private bar guild, as public trustees, acting as judges, prosecutors, and magistrates, are immune from any personal accountability for their actions. And, number 5, the presumption of summons is that by custom, a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned, with a copy of the rejection filed prior to choosing to visit to or attend. Jurisdiction and position as the accused and the existence of, quote, guilt, unquote, stands. And, number 6, the presumption of custody is that by custom, a summons or warrant for arrest unrebutted stands, and therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by, quote, custodians, unquote. This includes the dead legal fiction non-human, quote, person, unquote, that corporate governments, rules, and regulations are written for. Custodians may only lawfully hold custody of property and things, not flesh and blood, soul-possessing beings. Unless this presumption is openly challenged by rejection of summons and or at court, the presumption stands, you are a thing and property, and therefore lawfully able to be kept in custody by custodians. And, number 7, the presumption of court of guardians is the presumption that as you may be listed as a, quote, resident, unquote, of a ward of a local government area and have listed on your passport the letter P, you are a pauper, and therefore under the, quote, guardian, unquote, powers of the government and its agents as a, quote, court of guardians, unquote. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter before the court, the presumption stands, and you are by default a pauper and lunatic, and therefore must obey the rules of the clerk of guardians, which is the clerk of magistrates' court. Number 8. The presumption of Court of Trustees is that members of the private bar guild presume you accept the office of trustee as a public service and, quote, government employee, unquote, just by attending a Roman court. As such, courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged, used to state you are merely visiting by, quote, invitation, unquote, to clear up the matter, and you are not a government employee or public trustee in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because you, quote, appeared, unquote. And, number 9, the presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoint the judge/magistrate in the capacity of executor, while the prosecutor acts in the capacity of the beneficiary of the trust for the current matter. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter trust, before the court, the presumption stands, and you are by default the trustee, therefore must obey the rules of the executor, which is the judge/magistrate. And number 10, the presumption of Executor Json tort is the presumption that if the accused does seek to assert their right as executor and beneficiary over their body, mind, and soul, they are acting as an Executor Json tort or a, quote, false executor, unquote, challenging the rightful judge as executor. Therefore, the judge/magistrate assumes the role of true executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged by not only asserting one's position as executor as well as questioning if the judge or magistrate is seeking to act as Executor Json tort, the presumption stands, and a judge or magistrate of the private bar guild may seek to assistance of bailiffs or sheriffs to assert their false claim. And 11, the presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge/magistrate as executor has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions, then it stands by the time of pleading that you are incompetent, then the judge or magistrate can do what they need to keep you obedient. And, number 12, the presumption of guilt is the presumption that as it is presumed to be a private business meeting of the bar guild, you are guilty, whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice onto the public record or call a demurrer, then the presumption is you are guilty and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. This is the 12 presumptions of court.